Welcome to Learn Life. I'm Shashank Mishra here with the Senior Advocate of Supreme Court of India, Subodh Markandeji. This is a step by the Senior Counsel to discuss and aware about ongoing legal issues, laws, statutes, and other associated things. Topic of today is constitutionality of excommunication from religious section referred to 9 judges bench. So on that, my first question is, so please tell us all about the background of writ petition number 740 of 1986. Central Board of Daudi Bohra Community versus State of Maharashtra, which, which after a pendency of 37 years has been referred by the Constitution Bench, dated that is 10th February, to a large 9 judges constitutional bench.
So let's go back to the source of this very long litigation.
Yes, sir.
We should notice two events which happened before the constitution came into force. First is that a Privy Council, the Judicial Committee of the Privy Council, which was the last court of resort for an Indian litigant, in Hassan Ali versus Mansoor Ali, that is 1947, 25 Indian Appeals 1, held that this post, called Saidina, is the religious and temporal head of the Dawoodi Bohra community, which is, uh, a denomination of Shia Muslims. So that has concluded this one controversy as to who is the head of the community. So second thing which happened is that provincial legislature of Bombay, in keeping with the changing times and in public interest, enacted the Bombay Prevention of Excommunication Act 1949, which came into force on 1st of November 1949. Now, let us notice what is the next event. Next event is that one Tayyabji Musaji Koicha filed suit number 1262 of 1949 on the original side of the Bombay High Court, challenging his excommunication order.
Yes,
That
sir.
is to say, he was excommunicated from the community, which was passed before the act came into force. So, there the question of validity of that act arose, whether it has legislative competence, because before the constitution came into force, there were no fundamental rights. So the only question which could be raised was that the provincial legislature of Bombay had no legislative competence under the Government of India Act. So that question arose. In the meanwhile, while the suit was pending, on 26th January 1950, the Constitution of India also came into force. So the question as to whether the act was valid when tested on the anvil of Article 26 also arose. So those two questions arose, the legislative competence and the validity of the act uh, when tested on the uh, touchstone of Article 26.
Yes, sir.
Now, Justice J.C. Shah, by his judgment dated 21st uh,
Feb.
February 1951, upheld the validity of the Act on both the grounds, that is, of legislative competence as well as its being consistent with Article 26. Now, on appeal, the division bench consisting of Chief Justice M.C. Chagla and Justice P.N. Bhagwati upheld that judgment, but of course on different grounds. The High Court also granted leave to appeal to Supreme Court, giving rise to Civil Appeal number 99 of 1954. But the plaintiff, in the meanwhile, died, and the Supreme Court held that cause of action did not survive. So the Civil Appeal 99 of 1954 was dismissed. Now, the present controversy arises. So the chief of this community called Sardar Saidina Tahir Saifuddin, he claiming to be the spiritual and temporal head of Dawoodi Bohras, which is a denomination of Shia Muslims, he filed in the Supreme Court writ petition number 128 of 1958, challenging the act as violative of Article 26 and seeking a writ of mandamus preventing the state of Bombay from enforcing the act. That writ petition was allowed by a majority of 4 to 1 of the Constitution bench. The judgment is dated 9th of January 1962. So, three separate judgments were delivered. First by Chief Justice of India, Mr. Justice B.P. Sinha. He proposed that writ petition should be dismissed. Second judgment was by Justice Dasagupta for himself, Justice A.K. Sarkar and Justice J.R. Mudholkar. And third concurring judgment was by Justice Iyengar. All the judges were unanimous in accepting the correctness of judgment of the Privy Council in Hassan Ali versus Mansoor Ali, to which I made reference earlier, wherein Saidina was held to be the chief ecclesiastical and temporal head of the Dawoodi Bohra community. So they accepted the Privy Council judgment and said that yes, there is no doubt that he is the head of the Bohra community. Now, the last event which we must notice is that one writ petition number 740 of 1986 under Article 32 of the Constitution was filed. And that was titled as Central Board of Dawoodi Bohra Community versus State of Maharashtra, which has been referred to now to a larger 9-judge constitution bench by the judgment which is now under consideration. So after 37 years of the pendency of the writ petition in the Supreme Court, it has been referred to a bench of 9 judges. So that judgment is dated 10th of February 2023 by 5-judge constitution bench, and the writ petition which lay pending for the last 37 years, and it saw a lot of ups and downs, and ultimately now it has been referred to a bench of 9 honorable judges. So let us see what are the events. So this writ petition obviously seems to be, against the Saidina. So probably they think that, he should not have such power or whatever. Those questions still remain. So this writ petition was filed on 26th of February 1986. It contained a prayer for reference, reconsideration and overruling of the earlier 5-judge constitution bench. This writ petition is entirely diametrically opposite to the writ petition in which the chief of this community succeeded. So there seems to be some resistance, some opposition to this Saidina. Now this writ petition, as I said, contained a prayer for reference to a 7-judge bench, because it asks for the reconsideration and kind of overruling the earlier judgment. So it was heard by a 2-judge bench on 25th of August 1986, and the bench issued rule nisi. Then on 18th of March 1994, the 2-judge bench directed it to be listed before 7-judge bench, and it came up before a 7-judge bench which directed it to be listed after decision in another writ petition Writ petition 317 of 1993. So the bench directed, seven judge bench directed that this should be listed after after the decision in that writ petition 317 of 1993. In the meanwhile, uh, respondent number two, that is Saidina, that is chief of this community, filed an interlocutory application number two for its listing before a division bench. In other words, he opposed the listing before a larger bench of seven judges. So the issue of reference to a larger bench was heard. So this was heard by a five-judge constitution bench, which by judgment dated 17/12/2004 held as follows. So I'm quoting from the judgment. The matter should be placed before a constitution bench of five judges and not before a larger bench of seven judges. It is only if the constitution bench doubts the correctness of the law laid down in Sardar Saidina Saifuddin Sahib's case that it may opine in favor of hearing by a larger bench consisting of seven judges or such other strength as the Chief Justice of India may, in exercise of his power to frame a roster, may deem fit to constitute. So, this is the order which I have quoted. But that bench could itself have decided whether it should go before seven judges or it could have easily decided when it has referred it to a five judge bench. So, I don't know. So, this is
Yes,
how,
sir.
the tendency, layers and layers of. So, that is how the five judge bench, the present five judge bench,
Yes, sir.
considered the matter and reserved its judgment, which has been delivered on 10th of February
Reach to the.
after more than 18 years of the reference. So 18 years have passed since the earlier five judge bench.
Yes, sir.
So
Sir, can
now
you
this is how the things are.
Sir, can you tell us what are the grounds in present petition number 740 of 1986 for questioning the correctness of law laid down in the earlier judgment of Sardar Saidina Saifuddin Sahib relating to the excommunication of the Bohra community?
Yes. So as per the present judgment, two grounds which require earlier 1962 judgment to be reconsidered are these two. So the court has held that earlier judgment did not undertake the balancing act of the rights respectively contained in clause B of article 26 and the right to life under article 21 of the constitution. So the court is of the view that you have to balance the two rights, that is the right under article 26 to 26b and article 21. The second ground is that the practice of excommunication of a member of a community itself needs to be tested on the touchstone of constitutional morality. So the court is of the view that the practice of excommunication, this is a practice, this is a established practice and upheld by a judicial
Yes, sir.
committee of Privy Council. So this practice, because the practice has so many ramifications. It adversely affects the member who is excommunicated. He is not entitled to all the facilities and other things of the community. So these are the grounds, and these grounds, court has held they arise in the backdrop of the development of constitutional law, particularly the recent three cases. That is K.S. Puttaswamy's case, Navtej Johar's case, and Indian Young Lawyers Association versus Union of India. So it is in the light of these three cases that the question has to be decided. So for me, it is best to quote the judgment itself, a small quote. So I'm quoting. Interpretation of various provisions of the Constitution made by this court decades back has undergone drastic changes. So, this is the rationale. So, on this rationale, they have sent back the they have sent the matter to 9 judges Constitution bench. Probably also because that Sabrimala judgment, is
Yes, sir.
which was in which there was a dissenting judgment of Justice Malhotra. So
Mhm.
that is under consideration by a 9 judge bench. So this will also be considered along with that.
Sir, what is the reason for the reference to the nine judgments, sir?
Yes, the reason for reference to 9 judge bench is that these very two questions arise for decisive adjudication in the Sabrimala case, which has been referred to a 9 judge bench. I will aptly quote the judgment which the present judgment has quoted, Justice D.Y. Chandrachud, as he then was. Now he is Chief Justice. So his quotation is the best thing which I can answer your question. So
Yes,
I'm
sir.
quoting. While the Constitution is solicitous in its protection of religious freedoms as well as denominational rights, dignity, liberty, and equality constitute the trinity which defines the faith of the Constitution. So, this is the reasoning that although, all these religious rights are important, but it has to be viewed only in the context of dignity, liberty, and equality.
Sir, with that, we will be concluding today's session, which was an amazing session, sir. Thank you,
But
sir,
I
for
have
joining in.
a take. You have not
Yes,
put the question, but I have a take. I
yes,
think
sir.
I don't accept the correctness of uh, Judicial Committee of Privy Council judgment
Yes, sir.
because too much power has been given, in one man, and that's a judgment before Constitution came into force.
Of course, sir. Of course, sir.
At that time, there was no Constitution. Therefore, whether so much of power should be, and that also he's a hereditary head or whatever, and that was
Mhm.
not a contest as the as you have seen, no present contest is between Saidina and the other members of the community or whatever,
Yes, sir.
dissenting members of the community or whatever. This Privy Council case was a case between, two contenders for that particular post. So there are two differences. One
Yes, sir.
is constitution was not in force. Secondly, the contest was not between the community at large and Saidina, but the two contenders for that post. So these are the two differences.
Yes, sir.
So in my view, the Privy Council judgment itself requires reconsideration.